And we're live. Today is Sunday, September 24th. This is our makeup class on the topic of Easements 1. Only one of your classmates decided to come today. I commend her in the highest terms possible. For those of you who are watching at home, please send me an email within a week to certify that you've actually watched it. After that, you'll be marked absent. So we did run attendance today, but if you certify your attendance by email, I will mark you as excused. Our discussion today focuses on easements, but I want to bridge this discussion from last week and the question of nuisance. And we talked about different types of nuisances, air, light, water, pollution, whatever it happens to be. But we introduced this new concept, right, that there might be other ways of stopping a nuisance other than suing for damages or an injunction. And this was a true or false question. It worked better with more than one person here, so I'll walk you through it. But the short answer is, what if you pay someone before litigation begins to commit a nuisance, right? What if you know that your factory is going to be polluting? And rather than waiting to get sued, you go to the property next door and say, hey, look, I'm going to pay you some money so I can pollute on your land. And the neighbor may say, sure. Or the neighbor may say, no way. But if the neighbor says, yeah, absolutely, you're going to want something more than that, right? Because what happens if the neighbor sells it and then the guy who buys it isn't happy with his pollution? So the topic for our next class, what are called easements and covenants, is how private parties can ensure that they can use someone else's land for the future, not just now, but in the future. And the question becomes, how do you control someone else's land without buying it? Now, of course, the easiest way is buy someone else's property. That's fairly straightforward. But what an easement or covenant allows you to do is use it. You don't own it, but you can use it. And we discussed easements, you may recall, the very first week or so of the semester, when we talked about adverse possession, right? You may remember the concept of a prescriptive easement. What is a prescriptive easement? If you walk along someone's property every day for a decade, and you do it with hostility, with notoriety that's open, after some time, the courts will claim that you've gained the right to use that land. Now, it's not straight up adverse possession, because you don't own Blackacre. But what you do have is the right to cross over Blackacre. And that's what we called a prescriptive easement, right? That was the phrase we used. A prescriptive easement. Okay? So an easement is just one kind of what are called servitudes, right? This entire topic is called the law of servitudes. I don't use the word servitudes very often because it's somewhat confusing, but the word is helpful because the key phrase there is serve, right? Where one piece of land is serving another piece of land, okay? And there are two major kinds of servitudes. There's easements, and they're covenants. Easements and covenants. One of the most confusing aspects of this topic is how do you know which is which? You'll learn, but one way that I can make this easier for you is by giving you a very simple rule. On the exam, I'll tell you something's an easement or a covenant, right? I'm not going to make you try and guess which is which because frankly there's not much of a difference. They have so much overlap. But the flip side of that is, if I tell you something's an easement, don't apply the rules for covenants. And if I tell you something's a covenant, don't give me the rules for an easement. Right? Those are the biggest mistakes in the on the final exam, whenever I grade every year without fail. Students start analyzing a covenant as if it were an easement, and they start analyzing easement as if it were a covenant. They're not, they're different things. Make sure you apply the correct rules. Don't screw that up. Okay, any questions, Lindsay?
No.
Okay.
Makes sense.
Okay, good. good. I always want to help you guys. I don't want you to run astray, so make sure you put that in your notes very clearly up front.
Then I'm assuming the answer to that problem was false.
Yeah, so the lead-off question, to go back to it, the only way to print a nuisance is by suing for damages. It's simply false. If you know that you're going to be polluting into your neighbor's stream, right, you can just say, hey, I'll give you $1 million to pollute. Sorry, this whole thing popped up. And that gives you the right to do it. But you have to do it in such a way that even if your neighbor sells the property, you're still protected by it. Right? That's the important point of how to structure these. Okay? So the history, as with most of property, the history of easements and covenants is a function of practice, not really logic. The case law doesn't necessarily make sense unless you know this history. So what you have to understand is that a common law back in jolly old England, all land was basically open. The idea of a fence, right, where you know, okay, this is my property, this is your property. Fences didn't really exist the same way that we know they exist in modern times. So what happened is, say you're a farmer, okay, this is my strip of land and that's your strip of land, okay? Everyone knows where their strip of land is, and everyone farmed it. But then what happens when you have people raising livestock? And they had cows, and they had chickens, and they had sheep and whatever else. As livestock raising became a much more profitable form of employment, people started grazing their animals on other people's farmlands, right? And this creates problems, right? You're growing your wheat, you're growing your whatever, and then some guy brings his cows over and eats all of your wheat. The cows eat wheat? I don't know. Whatever. They eat whatever the livestock is. So soon, with time, enclosures began. And enclosure is basically exactly what it sounds like, a fence. It says, this is my property, you can't graze your cattle here. But simply putting up a fence doesn't mean the cows are suddenly not hungry anymore. The cows are still hungry. They need to eat somewhere. And as a result, land use started to develop such that people allowed their land to be grazed upon, right? If you're a farmer and you have, say 10 acres of farmland, and maybe a couple acres of just grass that's not really arable for planting, you say, yeah, sure, bring your cows here, bring your sheep here, and you can graze them, okay? But pay me for it. And this is how the idea of an easement or servitude began. You basically allowed someone else to trespass on your land for money. This also worked with things like water. Let's say you have a lake on your property, and someone needed to bring their animals to drink. So you say, okay, you can bring your cows here for a certain amount of money, or whatever it was, and they can drink water from my lake. But this wasn't just a matter of allowing someone onto your property to do something, right? Chickens, whatever. It also applied to pollution. So as the industrial era began to develop, the rule was, okay, we're going to start polluting downstream, or we're going to block off a dam. We're going to block off a river to build a dam, to build a power plant. Again, you're denying someone their water, their clean water. So you can again pay someone to pollute. This is more or less the rule in Boomer, right? You're paying someone to screw up your property. But unlike Boomer, this is not done through litigation. This is done by a private arm's length agreement, whereby the parties agree that they're bound and future owners are bound to make certain uses of the land. Make sense? Okay. So there are two types of easements that I want you to be familiar with. And the terminology here is very important. The reason why the terminology is important is because if you use the wrong label, right? If you use the wrong label, your analysis will be totally wrong. So while I promised you a minute ago that I will tell you in the exam if it's an easement or covenant, I'm not going to tell you whether it's an easement appurtenant or an easement in gross. That you're going to have to figure out from the facts. Understood? Okay. So let's think about this from a big picture, putting aside these labels for a minute. What are two ways that an easement might work? Well, one way it might work is it says whoever lives on Blackacre can graze their chickens on Whiteacre, right? That way, if I'm on Blackacre today, and then my son inherits Blackacre from me in 20 years, and then my grandson inherits it from him in 20 years from then, whoever lives on Blackacre always has a place to graze chickens, right? Today, family businesses are fine, but back then that was a way of life. You kept your family lineage year after year after year. Or, let's say I'm a fairly wealthy person and I move around a lot. Let's say I own Whiteacre, Blackacre, Greenacre, Yellowacre. And I always, no matter where I am, I want to be able to bring my chickens to graze in a certain spot. Well, then I can make it not for the benefit of my land, but the benefit of me, the owner of the property. Okay? That's exactly the distinction between easement appurtenant and the easement in gross, right? The easement appurtenant gives a right to a person who owns land that the easement benefits. Let me say it again. The easement appurtenant gives the right, okay, to a person who owns land that the easement benefits. So whoever happens to own Blackacre at that time, he can benefit from the easement. So if Blackacre sold from A to B and B to C, that's fine. The easement in gross, though, operates differently. It gives the right to a specific person that the easement benefits. It gives the right to a specific person that the easement benefits. That way, if the seller, if the owner moves around a lot, even if he sells Blackacre, he'll still have the opportunity to raise his chickens and water his cows, whatever else you want to do on Blackacre, right? You have to decide which one you're going to pick because the rules are different for each. Okay, make sense? Okay.
I think.
Okay, I want to introduce one more terminology. There are two types of easement appurtenance. There are two aspects to easement appurtenance. There's a dominant tenement or estate, synonymous, and a servient tenement or estate. Dominant, sorry. The names are exactly what they sound like. Okay? The dominant tenement is one that benefits. The servient tenement is one that serves. It's exactly what the name sounds like. So if the owner of Blackacre gets to water his chickens, Blackacre is the dominant tenement. If the pond is on Whiteacre, Whiteacre is a servient tenement. So the dominant tenement is the one that's benefiting from the easement, and the servient tenement is the one that's serving, that's giving up something. Okay? Now, here's where terminology matters, right? With easement in gross, there's a servient tenement. Because, right, there's the one piece of property where the chickens be watered. But there is no dominant tenement. Okay, there's no dominant tenement. Why? Because there's no specific piece of land that benefits. The benefit goes to the person who owns the easement, right? So the person benefits, but there's not a dominant estate. Okay? Make sense?
Mm-hmm.
Okay. So make sure you get your terminology correct, right? If on the exam I give you an easement and it looks like an easement in gross, don't tell me about the dominant tenement, because if you do that, I'll know you don't know what you're talking about, right? Only talk about dominant tenements and servient tenements in the context of the easement appurtenant. And the word appurtenant is a word that's not used very often. It basically means attached, right? Attached to the land. So even the word itself is attached to the land. The word gross generally means benefit, right? So it's a benefit of a person, whereas the easement appurtenant attaches to the land. Okay? Now, here's another important distinction between the two of them. With an easement appurtenant, you have a dominant tenement and a servient tenement. Lindsay, does it matter who's living on the property at any given time? It does not, that's right. Whoever happens to own Blackacre at the time, and whoever happens to own Whiteacre at the time, is now stuck with this arrangement, okay? It goes down the chain. So, we'll give an example, right? Make it easy. So you have two properties. You have Whiteacre the dry acre. I'm very original, I know. You have wet acre and you have dry acre. Wet acre has a pond on it, dry acre does not have a pond on it. Okay? So let's say that wet acre is owned, I'm sorry. Okay, let's say that A owns both wet acre and dry acre, okay? He owns both. A conveys wet acre to to B, but retains an easement. Okay? So A owns both wet acre and dry acre. He sells the land, wet acre, to B, but he retains an easement. Okay? And for reasons I can explain later, this is going to be an easement appurtenant. Okay? Because it's not specifying for his benefit. So now, which is a dominant tenement and which is a servient? Lindsay, what do you think? Which is dominant, which is servient?
Like with A and B?
Yeah. No, no, I'm asking for pieces of land, right? That's the important point. When I ask for a tenement, I'm asking for a piece of land, not a person's name. So which one's dominant here, which one's servient?
A is dominant.
No, I'm not asking for a name.
You're asking what acre is dominant. No, what acre is servient?
Yes.
What acre is servient?
Exactly.
Okay, getting it now.
Yeah, okay.
Yeah.
Why is wet acre servient and dry acre dominant?
Well,
Which is serving which?
What acre is serving dry acre? Because the
Exactly.
pond's on what acre?
Exactly. Don't get that twisted, right? The servient tenement is the one with the goods. It's the one with the water. It's providing the service. The dominant tenement is the one that's benefiting from it. The dry one without the water. Okay? This is a very common mistake. And you go, oh, of course, the one with the water is the dominant one, right? No. Which one is doing the serving? Wet acre. Therefore, wet acre is the servient. Which one's benefiting? Dry acre. Dry acre is therefore the dominant tenement. Okay? Okay. Now let me change this question up, right? A conveys wet acre to B, but retains an easement in gross. Okay? All right, it's a very similar question, but instead of retaining an easement appurtenant, they retain an easement in gross.
So it's only a servient tenement.
Bingo. Yeah, so the servient, right, is still wet acre,
Right.
but there's no dominant because it's a benefit for B, I'm sorry, for A and A alone. So that's the big difference, right? When you're talking about dominant and servient tenements, you gotta give me names of properties, don't tell me A and B. It's a very common mistake people make on the exam. They say, oh, of course, it's dominant tenements A and servients B. No. Give me names of property. White acre, black acre. Exactly. And the opposite, though, the easement in gross, you still have a servient tenement, but the dominant doesn't exist. It's a person who gets the benefit. All right, everyone okay with that? Everyone, one person. You know, it's the strangest thing. I instinctively look around, even though I'm in an empty room. It's a damnedest thing. It's a professor thing. Is I guess is drilled to my DNA. I can't get away from it. Lindsay, okay with this?
Yeah.
Okay, good.
Makes sense.
All right. So let's move on to the next topic of creating easements. Okay. An easement must be written. Why? Statute for frauds. Okay. An easement must be written. It has to be within the statute of frauds. That it must be signed by the party to be bound. Okay. But there are exceptions, as always, to the statute of frauds. What are the exceptions? Well, you have adverse possession, which is called a prescriptive easement. Okay, prescriptive easement. You also have what can generally be called estoppel, or easement created by implication. This is your general fairness. It's like, wow, it'd be really unfair to deny this person the right. That's not the same as adverse possession, but there are lots of overlaps. So the first case concerns the how easements are created. Now, if you notice, when I gave you these examples before, I wrote it in a very specific way. I said, A conveys wet acre to B, but retains an easement appurtenant. At common law, if you wanted to create an easement, you actually have to do it as part of a land transaction, right? You couldn't just say, hey, I'm Josh, I own Blackacre, I want to give Lindsay an easement. That didn't work. You have to actually sell the land with the easement on it. The modern approach, I think, as the first case from California explains, is to abandon that. Because it's a lot of work to have to sell an entire piece of property just to retain an easement. So the first case, this Willard versus First Church of the Christ, Scientists, California, Supreme Court, 1972, asks whether a person selling the property can reserve an interest in a third person. Again, traditionally, the only way to reserve an easement was to actually sell it to the person holding back. But this California case says, can you just make a transaction and then put the easement for the benefit of a third party? Make sense? Okay. Lindsay, I'm sorry, you're on call. You want to give me the facts, please, in the Willard case?
Yeah. Okay, so you have this lady, Genevieve McGuigan.
Good.
And so she has two lots, lot 19 and lot 20. So lot 19 had a building on it,
Okay.
so she conveyed that to Peterson, and then Peterson conveyed that to Willard. But
Well,
then,
for some time, even before this, how was the land being used, lots 19 and 20?
okay, yeah, lot 20, with her.
Yeah, how was the land being
Well,
used
she
even
was
before these
letting,
transactions began?
On lot 20, she was allowing a church to use lot 20 for parking.
Very good, very good.
And so that's the lot that's at issue.
So here's a rough diagram. So you can imagine this, the church is here, Miss McGugan lives across the street on number 19, lot 20 is vacant. Okay? And as a good Samaritan, or whatever it is, good parishioner, she allows the church parking to go into lot 20. And this is generally going to be on Sundays, maybe during the week, but most time of the week the lot's empty. Now, there's no claim that the church acquired the right to park there through adverse possession. Why? It was voluntary, right? Miss McGugan was voluntarily allowing them to use it for parking lot. She was very nice. And then she decides to sell lot 19. Okay? So Peterson bought lot 19. He did not buy lot 20 though, at least not right away. And this is again why I tell you in all my exams, people commit fraud. It's, without fail, people are going to commit fraud. So lot 19 is sold. Then Peterson's like, wait a minute, I want to sell lots 19 and 20. So Peterson gives Willard, his realtor, a deed for both lots in fee simple. Again, he only owned lot 19. Why the real estate company didn't do a title search, I don't know, right? Maybe they thought something was up, who knows. So then Peterson approached McGugan with an offer to buy lot 20. McGugan, though, wasn't a fool. She said, look, I'll sell you this so long as a church can use it for parking. Now, ask yourself, what good is a piece of property if every Sunday it's going to be filled up with cars? Can you build anything there? No. One student a couple of years ago said, well, if you put billboards, okay, that's actually a good idea. That's a good idea. Maybe you put a billboard up, right? Someone else said build a parking lot, which I guess is a very good idea, but this seems residential. There might not be a reason why you need a parking lot. But it's pretty good reasoning that if Peterson sold this lot 20, it was to build real estate, right? If you look at this Google Maps, there's actually stuff there now, okay? But anyway, McGugan said that's fine, right? And the church attorney put an easement in the property. And it said, in this transaction between Peterson and McGugan, the church benefits from this easement. And the easement runs with the land, so long as the property is used as a church, right? This idea of run with the land, we'll talk about that later, but it means is each successive owner is now subject to this easement, right? So this is what we describe as an easement appurtenant. It's not an easement in gross. It attaches to the lot of the church, right? The church benefits from it. So the dominant tenement is the church, and the servient tenement is lot number 20. Okay? Now, Peterson was aware of this easement, but when he sold it to Willard a few days later, he didn't mention in the deed his easement for parking. Again, people commit fraud all the time in this class. You can report whatever you want. No one even cares. Peterson, I think, may have mentioned to Willard that the church would use his parking, but he didn't mention easements, right? Because think about it. You say, oh yeah, this old lady, maybe she was an old lady, but you know, Miss McGugan, I once got in trouble. My mom was attending my class. I said old lady. She's like, don't say that. So I don't say old lady anymore. But Miss McGugan may have been, you know, letting the church use it gratuitously for free, but now Willard's the owner. They can kick out the church. But all good things come to an end, and Willard became aware of the easement. So Willard, recognizing that he got screwed over by Peterson, basically got had. Peterson's out of the picture at this point. Willard seeks a quiet title. And this is a phrase that you're going to see over and over and over again in property. Quiet title, it's not like shh, right? It's not like quiet. It's you're asking a court to determine the ownership of land, right? You're saying, look, we don't exactly know the status of this easement, so we're asking you, judge, to make a resolution and to settle the title of the property. That's what means a quiet title. So Willard brought suit to quiet title against the church. McGugan testified that she would have only sold only sold the lot if this easement was present. In fact, she said, because of this thing, I lowered the price by 1/3 because I realized people couldn't use it for much, right? Why would anyone want a lot that one day a week as we fill up with churchgoers? You can't really do much with that. But then the question was this, right? Under California law, could you reserve an easement in a third party? Now, you're all good students, those of you watching at home, and Lindsay here. This is a case from California. You know what's going to happen. What's going to happen?
Reverse common law.
Yeah, exactly. You know the drill by now. You guys have been here for a month or so. They're going to reverse the common law. That's what they're going to do. And that's exactly what they do. They say, look, under this common law rule, you can't reserve an easement for the benefit of a third party, but they refer to that as an apposite feudal shackle, right? Whenever you see an opinion using the word feudalism or mentioning liver of season, remember the clump of dirt and the twig, they're about to reverse the common law. There's no doubt about what they're about to do. So the court says that you can now have a reservation for a third party. You don't need to go through these formalities, right? So Lindsay, let me ask you this question. Under the old approach, how would they have had to retain an easement if they couldn't benefit from the third party? How would they have had to do this?
Oh, I read it in the notes.
It wasn't. It was very good. I'm glad
Yeah,
someone's
but
reading it.
I can't remember. It was like it was called re-granting or
Good.
something, but I can't
So
tell you exactly
let's try and walk through this. It'll help people at home. In the example we gave before, how is an interest reserved from A to B? What had to be done under common law to retain an easement?
Oh, you have to have reserved an interest for yourself.
In what transaction? Who to whom?
Between A and B?
Well, so who's benefiting from here, right? Who's benefiting from this easement in our case?
Whoever's owning Dry Acre.
Well, go back to the church, right?
Dry Acre.
So who's benefiting?
Oh, here.
Yeah. So who's benefiting in the
The
church
church.
case? So how would the church retain for itself an easement? What would have to happen first? In order for the church to benefit itself, how would that have to happen?
McGugan would have to convey
Yes.
to them. To the
Exactly
church.
right. So it's a multi-step process. You're exactly right. So you need to do 2 transactions, right? First, McGugan, can't spell her name, would convey a fee simple to the church, right? She can do that. Second, the church conveys a fee simple to Peterson, reserving the easement. Everyone see that? All one of you, right? Under the common law, in order to retain an easement, it has to be a transaction between the party that benefits and the party that's serving. So first, McGugan would have to convey the fee simple to the church, and the church gives fee simple to Peterson, but reserving the easement. And that's fine because the easement benefits the church, and the serving tenement is a parking lot, right? So in this case, let's make it clear. The parking lot is equal to the servient, and the church is equal to the dominant. That is how you'd have to do the common law. But the California Supreme Court abandons that, saying, look, it's a waste of time. Because what's the risk here, right? Lindsay, what happens if McGugan conveys fee simple to the church, and the church's like, yeah, never mind. I don't want to do anything else, we're done.
And they're just going to keep the property.
Can they
and
be
then
forced to
Peterson-
give it back to Peterson?
No.
So that's the rub, right? Once you convey yourself fee simple, right? Once you convey fee simple to another party, it's theirs. And, maybe you trust them, maybe you don't. But Peterson has no guarantee of getting what he wants. Now, you can maybe have some sort of an agreement, a contract that if you fail to disclose this, you'll be subject to a breach of action, right? A breach of contract. But it's a risky proposition to do this 2-step transaction, simply because there's no guarantee that the church actually passes it forward. So what the California Supreme Court says is, we don't need to do this feudalism stuff, right? It's not necessary, it doesn't benefit anyone, it creates unnecessary transactions, it creates unnecessary complications, we are simply going to abandon it, and they overturn the common law rule. So now, under the modern approach, and this is pretty well developed, you can retain an easement for the benefit of the third party without having to do a third transaction. You just sell it from A to B and say we're benefiting C, and that's good enough.
Question?
Yes, you're raising your hand.
So-
That's great. Thank you.
So Peterson here,
Yeah.
so what he was trying to do, I guess, was he knew there was gonna be an easement, so he was gonna get the property, buy the property super cheap
Yeah.
from
And
whatever
not tell
her
the
name
other guy
is,
about it.
and then sell it more expensive to Willard. Is that what he was
Exactly.
trying to do?
Exactly, yes.
And then I just don't understand how Willard could not have known this, I guess.
I don't know. If Willard was a realtor, he's a dumb one,
It,
right?
yeah.
He got had, right? He got
Yeah.
scammed.
So like, I was like, well, why wouldn't Willard just go up to and buy the lot 20?
Well, because Peterson
he thought
told,
that he had lots, that
right,
Peterson owned
Peterson
lots 20,
told
right?
Willard that he already bought lots 19 and 20. So he wouldn't even think of going to Ms. McGugan. He wouldn't even think about it. But he apparently didn't do a title search. It's also possible that Willard was not exactly scrupulous either. He may have known that they were taking advantage of this woman, but he didn't think there was an actual recorded easement. Like, imagine this, like he said, like, Peter said, hey, there's this lady was letting the church use it, but, once you own it, you can do whatever you want. That's fraud. He failed to disclose the easement, which runs with the land, but Willard bought it anyway. So he has unclean hands, and I don't have much sympathy for him. He should have known that something was up.
Yeah, no,
Right.
I agree.
Yeah. All right, makes sense?
Yep.
All right, so the general rule then with easements is they have to be in writing. And under the modern rule, you can reserve an easement for the benefit of a third party. You don't need a separate transaction. Okay? You don't need a separate transaction. Anything else? Any thoughts? Okay, I guess it's pretty straightforward. The next topic often confuses students because they ask, what's the difference, Josh, between an easement and a license, right? An easement and a license. The biggest difference between an easement and a license is an easement has to be in writing. Right, it must satisfy the statute of frauds. A license can be oral, right? What is a license? It's basically oral permission to allow someone to trespass. Right? You are orally giving someone a right to trespass. Now, we've all done this, right? If you have guests at your home for dinner, they're licensees. If you have a plumber who needs to come over to fix your toilet, he's a licensee. Now, the trick is when you invite someone to your house, it's revocable at any time. If the guest overstays his welcome, you can toss him out and say, I'm revoking my license, leave, or I'll call the police for a trespass. If the plumber refuses to leave, I guess it's possible, you can then sue for a trespass as well. Okay? But the reason why this topic isn't so straightforward is that there might be certain circumstances where a license is not revocable. Right? A license might not be revocable. And there's a couple of circumstances where it might be non-revocable. Estoppel, which is your general fairness, and also some sort of a prescription or an implied right. There's not much of a difference between the two of these. I think it generally reflects the fact that the court has a sense of fairness, and if they think that someone has benefited from this and they ought to keep benefiting from it, they will make the license revocable. So I don't want you to get too bogged down, whether it's estoppel, prescription, because I've been teaching this for years, they overlap significantly. Whoa!
We thought it was 517.
Oh.
It's chilling up there too fast.
I knew it. I knew I should have gone up there and.
Well,
You're Robert and David.
No, I'm gonna go find him.
are there others?
Yeah.
I'll take the 5-minute break now. I'm sorry, wasn't there a sign on the door? Someone's supposed to put a sign on the door. I am really sorry about that.
Oh,
Well, we're almost done, actually. We're about to do the licenses case, so I'll let Lindsay off the hook and How did you figure out this was the room?
We've been writing on the board.
Oh, God, I'm sorry.
It's okay.
I had asked them to put a note on the door, because that room was not available.
Okay. Well, we were worried because part of I-10 is closed and we were like, we don't know where he lives, so maybe we should run late.
Poor Lindsay
He
was
can't
stuck.
email because he's
Something
driving.
told me to go up there too, and I was like, I shouldn't just go up there. I feel like people probably don't know it's down in this room. He's like, no, there's a thing on the door.
There was a note on the door, I'm sorry.
Yeah, and there was one on
Someone must have
Friday.
taken it down?
Yeah,
I'm
there
sorry.
was one on Friday.
Alright, well, we'll take a brief break. I'll summarize also for your benefit. I already closed the attendance thing, so I'll just mark you present now.
Okay.
I appreciate your name tag, it's very considerate. Avery, what's your last name?
Addison.
Thank you. You're first alphabetically, okay. We always at first alphabetically?
Yeah, except for like if there's anyone like Adams or something like that.
And then what's his last name?
John Paul is like Calero or Caleo or something.
Here we go.
Are there people watching right now?
Yeah, there's people watching at home.
That's how we figured out that you weren't late. I was like, I'm gonna check this.
And
And I
I'll
saw
teach
it was
you.
live and I was like, what room looks like that?
Oh, that's funny. So there are 4 people watching right now. I'm sorry, guys.
That's fine.
There was supposed to be a note that was on the door to inform you that we moved rooms.
The note was on another classroom's door.
Are you really? I'm
Yes,
sorry.
it was on the note. You put it on 517?
I didn't put it.
Okay,
It was
so
on the one across.
it was on the one across, like a little bit more down the hall, so we were just hanging out in 517. and
Well,
we didn't think-
Yeah, we were passing through and looking for lights, and so once we didn't see that the lights were on in that classroom.
I'm really sorry. That was a screw up. I'm sorry about that. Well, poor Lindsay's been here for half an hour, and
Thanks, guys.
I'll mark all of you present. The people watching home can jump all. What's your last name again? Huh? What's your last name again?
Gutierrez, Gutierrez.
I'm really sorry that this was a screw up. The note was in the wrong door. That was. What's your last name, sir?
Puerta with H.
H. Robert. There we go. Okay, so let me summarize then what I've been talking about the first half hour, and you can catch a video later. I'm sorry I made you come here for. We have this concept of the law of servitudes. And under the law of servitudes, you're basically allowing someone else to either commit a trespass or create a nuisance on your land, right? Usually nuisances or trespass result in litigation. But with a servitude that is a covenant or an easement, you can actually allow someone in advance to trespass on your land. Or you can allow someone in advance to commit a nuisance on your land. Okay? We'll cover covenants next week, but I want to make one point very clear. The differences between a covenant and a nuisance is very subtle. I'm not going to trick you on an exam by asking which is a covenant, which is an easement. I'll tell you if something's a covenant or easement. But the implication of that is that you have to apply the right rules. If I give you something called the easement, you have to apply the easement rules. If I give you something called a covenant, you have to apply the covenant rules. One of the most common mistakes that are made on exams is that students apply a covenant to an easement, and they apply the easement to a covenant. They screw it up. Okay, so get that straight. We discussed before that there are 2 types of easements that you have to study. Okay, the first type, what's called an easement appurtenant, reflects an easement where there's one property benefiting and one property serving. Okay? With an easement appurtenant, you have one dominant tenement, that's one that's benefiting, and you have one serving tenement, that's the one that's serving. So I'll use the example I gave to poor Lindsay before, right? Use this example. A owns wet acre and dry acre. Wet acre has a pond on it. Dry acre does not. Okay? So A owns both of them. A conveys wet acre to B, but he knows that he needs access to water. So he retains an easement appurtenant, right? That way whoever owns dry acre can still bring his chickens or cows, whatever else, onto wet acre for water. In such a case, we say that the dominant tenement is dry acre, and the servient tenement is wet acre. Okay, make sense? Everyone okay with that so far? Question, stop me. This is summarizing before. And I will excuse all five of you having to watch the first half of the video, but if you want to, you're welcome to. But I very markedly present. There's a second type of easement that's worth discussing, which is easement in gross. Unlike the easement appurtenant, which benefits a piece of property, an easement in gross benefits a specific person. Okay? The key point with an easement in gross is that there's no servient tenement. I'm sorry, there's no dominant tenement. With an easement in gross, there's only a servient tenement. So let's use the example we gave before, just a little bit differently. This one right here. A conveys wet acre to B, but retains an easement in gross. We would say that the servient tenement is wet acre, because that's what's doing the serving. Don't fall in the trap thinking, oh, the one with water is dominant, it's better. No, no, no. It's which is serving which. So the dry acre is dominant, the wet acre is servient. But here, it's an easement in gross. So you still have a servient tenement, which is wet acre, but no dominant. No dominant. The benefit here is for A. So no matter where A lives, he can still trespass onto wet acre and use access to the water. That makes sense. It's a summary of the first half hour. Lindsay, is that about right?
Mm-hmm.
Okay, yeah, that did.
This is based on what I read in the supplement. Could it also be like an oil pipeline that runs across somebody's land? Is that also an easement in gross? Or?
Yeah, you can. You can structure an easement however you want. You can say an easement to carry water, an easement to carry gas, an easement to graze, cows on a field. The easement can be structured however you want. What I want you to appreciate is which one is dominant and which one's servient, right? So if there's an oil reserve on one property, and then you're transporting it to another property, the dominant tenement is the one that benefits, and the servient one is the one getting drilled on, right? That's where the pipeline begins. Make sense?
I guess also mention how the dominant tenement and servient tenement, you identify them by property and not party.
Thank you. Yes, thank you. See, you're paying attention. Another big difference is with an easement appurtenant. When I ask who's dominant and servient, give me the name of a property. Don't tell me A or B. Tell me dry acre or wet acre. Right? It benefits a property and whoever lives there, but not a person. In contrast, easement in gross benefits a person. Right? That's what gross means, a benefit. But there's still going to be a servient tenement. By the way, tenement and estate are synonymous. You'll see them different ways, different spellings. Okay, everyone with me? Everyone good? Okay, I've been classified. The reason why I didn't bother checking upstairs is that on a Thursday, for Friday, poor Lindsay and one other student with only one's here, so they're like, all right, one or two, that's bad, one's expecting, so glad I have more than 5. My common law class had 9 or 10, they kicked your asses, they beat you big time. Yeah, go ahead.
When it comes to, say, surface and mineral rights and severing those two, do those constructively work in a similar fashion, or is that completely different?
So, the ability to drill on someone's land, it's governed by the law of servitudes, but it's not an easement in the normal sense.
Okay.
It refers to royalties. And the reason why is that you're not just allowing someone to water their cows or to graze on your farm, you're actually extracting from the ground. So it's not just using what's there, but taking it away. So in Texas and in most states, an entire body of law is developed concerning the extraction of minerals and oil from the ground. You'll take oil and gas next year, and you'll see phrases similar to easements, but it's not exactly the same, because it's not just allowing you to drill, it's drill and take. They're discrete acts. Does that make sense?
Mm-hmm.
Thank you. Good question. All right, let me briefly summarize the first case, the Christian Scientist case. What happened here is you had a church that had all of its members parking on lot number 20 for years. The owner of lot 19 sold the church, sold her home, but she reserved an easement for the benefit of the church, saying that even after I sell this, on Sundays, whenever, people can still park in the church parking lot. The problem with this is that under the common law approach, you couldn't reserve an easement for the benefit of a third party. What you actually have to do is this. You have to do two transactions, right? So first, the owner has to convey the church in fee simple, has to convey the property to fee simple to the church. And then the church conveys it back to the buyer with reserving an easement, right? Everyone see what's going on here. You couldn't just say, I'm selling it to David and reserving an easement for Lindsay. You couldn't do that. It's, I'm gonna sell the church to David. David then sells it to Lindsay with the easement on top of it. You have to do two separate transactions. Make sense, David?
Yeah,
Right? You can't, under the common law, you can't benefit a third party, right? However, this is the big however, we're in California. And what do we know about a California decision? They're about to reverse the common law without fail. I don't even have to tell you the holding. You know what's going to be from the citation. So they refer to this as a feudal shackle. And if you ever see a discussion of a feudal shackle, you know that the common law is about to go down. They say there's no reason to require these two separate transactions. Allow McGugan to sell the church, to sell the parking lot to Peterson, and reserve the benefit of the third party. Okay? You don't need to do this extra step. So any questions on the church case?
I know you already discussed it.
I will do it again.
You said there was a hypothetical in the text about what if they sold the building, the church, to the Methodist church? And
Oh, that's a
moved-
good question, right? So what happened, I don't have the exact word in front of me, but it said for church purposes, right? So is that a benefit for the Church of Christ Scientist or of any church in that property? What do you think? Right, because the way
Oh,
they
okay,
drafted
sorry,
the
I-
easement, the way they drafted the easement, it said that this easement exists so long as the property is being used for church purposes as parking. What if they sold it to, Methodist, or maybe they sold it to a synagogue or a mosque, or a church of the Flying Spaghetti Monster, right? Or a church of Scientology? Would that fit within the scope of the easement?
I think you could argue, yes, it was like that building was used, maybe not Christian church, but maybe like worship.
Church of Satan, right? Or a Wiccan church. What do you think, Robert?
I think once it changes, it wouldn't, because at the end it talks about the intent.
That was I think that's my answer, right? The intent of this is not just church purposes specifically. McGugan's intent is for that church, that one church. So I suspect what would happen is, under this modern approach, because the benefit was reserved for this church, the court would keep it there. But then, is it an easement in gross or an easement appurtenant, right? If it's only for the benefit of that church and not the owner of that plot, how do we characterize it then? So I think that's right. I think under the court's holding, you have to view this as an easement in gross. Because if Robert's right, I think he is, it doesn't go with the land, it's only for this church, right? Then it's whatever. In fact, if you go to the Google map, I think the church is still there, but, stuff is developed, right? They built stuff here. So it might be that the church no longer has the monopoly. I mentioned this to Lindsay, but if you have a lot that's basically empty 6 days a week, and the seventh day when the Lord rested, cars show up, can you build anything there? The answer, I think, is no. One semester, a smart-ass student said, build billboards, right? Put up billboards, you can, or build a parking lot or garage or something. But generally speaking, I think the answer is that this is an easement in gross for the benefit of the church. Now, the better question, David, is what if the church moves a few blocks away? Can they still use this parking lot if it's an easement in gross? Oh, right. The Church of Christ Scientist moves away. They move a couple blocks away. They still use that lot.
You mean just like, I'm sorry, you said just a block away? Like just
1 block, 5 blocks? I don't know. Does it matter? If it's an easement in gross, does it matter where they go to? Right. So if the benefit is for the church itself and it's an easement in gross, even if the church shuts down, they can still let people park there. But then the question is it church purposes, are they actually selecting services? So it goes back to intent. I think eventually everything goes back to what the intent of the grantor, McGugan, was. All right, so questions on this? Questions on the Church of the Christ Scientist case? All right, so generally easements must be in writing. Under the common law, you couldn't benefit a third party, but under the modern approach, you can benefit a third party. You don't need to do this extra transaction. And I mentioned this to Lindsay a minute ago, but what happens if you go down this route with these two transactions, right? McGugan gives the church the fee simple. McGugan conveys the fee simple to the church. What if the church says, okay, peace, we're done. That's it, we own it. Screw you, Peterson, right? You're a crook. You're going to hell. There's nothing at that point that can be done to force the church to convey the easement to Peterson. They can just keep it. So there's a real risk in allowing the transaction to go in the two-step process. Any questions on that? Okay.
Oh,
Yeah, yeah.
So did you say that this was an example of an easement gross? Or?
I think it is. I think it is based on your own answer. I think it's better characterized as easement and gross. John Paul?
So, towards the notes, they were talking about, continuous transfer of the easement, by grantor.
Yeah.
And if I'm not really sure is it because that from grantor to grantee, title is conveyed subject to agreeing to the easement? Is that the,
Say it again?
so,
I don't think I followed your question. I lost in the middle.
so when they were talking about, subsequent transfers of the easement to
Right.
future, grantees, if I read this correctly, the reason that it can continue with subsequent transfers is because the grantor conveys the title to the grantee, and it's subject to agreeing to continuing the easement.
Yeah, the phrase we use is runs with the land.
Okay.
Right, that's the phrase we read the deed the church drew up. The phrase runs with the land is used. And that basically means grantor or grantee, it doesn't matter, you take it subject to the easement. Now, how do you get rid of the easement? Tell me, how would you actually get rid of the easement in this case? Say Peterson finds out about this and Willard finds out. How would Willard get rid of this easement if the only way they can get rid of it? What's the only way they could do it? What would they have to do to get rid of this easement on the land? David?
Purchase the,
From?
from,
Is that it?
From the church?
Yeah. So the only way for Willard to get out from under this easement is to buy off the church. Say, hey church, will you release the easement from us? Give you $1,000, whatever it is, right? Church says no, that's it, they're stuck. The only way to get out from an easement is basically buy off the owner, the dominant estate, or the easement and gross owner. You have to buy them off and hope they release it. If they don't release it, you're stuck, right? The notion of an easement running with the land means you're stuck with it for yourself, your grandkids, your great-grandkids, everyone. You can't eliminate it. Unless you have an adverse possession claim, a prescription claim, or something else. But generally speaking, you're stuck. Which is why you want to do a title search to see, are you buying land with an easement on it? If you are, maybe you shouldn't buy it.
So the easement in this case, the Willard Reverse Church, you're saying, so at first you said it was an easement after, I don't know.
I think it's probably better an easement and gross.
I think so too, but that's the.
But
okay.
let's say the church has been there for 100 years, they're not moving, right? If you want to get out from it, you have to buy it off,
Okay.
right?
Alright.
If the church moves and shuts down, I think under Robert's question is a good argument that the easement disappears. It's what we call fee simple determinable. It's determined, right? The condition ended, so you walk away from it. But so, and I think based on Google, that looks like a church with a little steeple, right? So I'm guessing the church is still there to this day, and maybe they worked out some deal. I don't know the answer. All right, questions on that? I'm gonna move that sign later for my second class, which starts at 2. I am so sorry. I'm really sorry, guys. I deliberately said put a sign up and. Okay, that was my fault. Okay.
We were about to leave and then we said, well, maybe he's live streaming it. We saw it here somewhere.
It's like in an undisclosed location, right? All right, let's do the last case and get out of here so you can get your Sundays back. Thankfully, no one took a knee during my class, I appreciate that. David, want to give me the facts, please, in Hallberg?
Yeah, I mean,
Thank you, sir. Yeah, take your time.
um,
I would love to have a class of 5 students, like Aristotle at this point. Unfortunately, we can't do this every day.
I'm sorry, you said Holbrook?
Holbrook versus Taylor.
Taylor.
Kentucky case, please.
Okay, the Holbrooks, they had a road and they granted permission to use it to, a mine.
Okay, good.
The mine closed and, the Holbrooks, they built a house on their property
Mhm.
and they granted, the tenants of that house, they granted permission to use the road.
Good. So was that adverse? Was there a claim for prescription at that point?
Adverse.
Adverse possession, I mean. Is there a claim for prescription?
At this point, I don't,
Why not? What's one of the elements of adverse possession or prescription that you need to have?
hostile or,
Hostile, right? You can't take property by adverse possession or prescription if it's permissive. In other words, if you have permission to cross a land, you don't meet the elements of adverse possession. And the elements for adverse possession are identical to the elements for prescription, right? I use the phrase up here, prescription. The difference is with adverse possession, you're getting fee simple to a piece of land. With prescription, you're merely getting an easement. You're getting the right to trespass across it. You don't own it, but you can trespass it. And think of, I mentioned earlier, the semester Rockefeller Center, right? There's a private sidewalk in Rockefeller Center, and every year they shut it down for one day. That way no one can say, I have a prescriptive easement right to walk across this every single day for a decade. No one's claiming to live there. They're saying if I walk across this land every day, I can get an easement by prescription. So by closing off the roadway one day a year, they make it clear that no one can get that. So this case involves a license, right? And what's the difference between an easement and a license? Writing. An easement must be in writing, subject to the statute of frauds. In contrast, a license is oral permission to allow someone to trespass. And you've all dealt with licenses. If you invite a friend over for dinner, you invite a plumber over to fix your toilet, right? You invite a repairman, whatever it is. That person has a license. The key difference between an easement and a license is with easements in writing, you're stuck, right? You can't get rid of it. But with an oral license, you can revoke it at any point. If your friend overstays his welcome, you say, get the hell out, right? If the plumber refuses to leave, you call the cops on him. It's like, what are you doing? Get out, you're weird, right? So easements and license are different, precisely because the license can be revoked, they're revocable. There are 2 exceptions, though, to a license being revoked. One is estoppel, the other is prescription, right? If there's some sort of reason why a court thinks it's unfair, they will continue to allow you to trespass. And I mentioned this to Lindsay a minute ago. Don't get bogged down in the difference between estoppel and prescription. They're pretty similar. They overlap a lot. Courts generally say is if you got oral permission to do something and you kept doing it for a long time, as a matter of fairness, we'll let you keep doing it. And the Holbrook case, the first case, is a good example of this, right? They admit that they don't have evidence of hostility, so there's no adverse possession claim. However, there is estoppel, right? Now, Robert, what made the estoppel claim here so strong? Right? Why was the plaintiff so sympathetic in this case? What did the plaintiff do to really...
They built their house and they improved the land.
Improve. That's the magic word, right? If you're a person who's crossing over land based on a license, and you make improvements, you spend money, you finish off the road, you build structures, whatever else, that makes courts very sympathetic to you. And here what we have is a situation where all this money was spent, made their road better, and then after some years, the owner's like, screw you, I'm gonna build a fence, I'm gonna build a wire, whatever it is, you can't cross it. Judges don't like when someone who's been doing something for a very long time has it disrupted. Judges say, if you were doing this for a long time, and you developed this land, you put investments in it, you concrete, whatever it is, right? We will let you do it. So the bottom line of this case is because of the money that was put into it, they said the license cannot be revoked, and it's estoppel. But I want you to think about what that means, right? Even though there's no deed, even though there's no easement on the deed, as a matter of course there is. And if the owner of the property sells it to someone else, that someone else has to deal with this guy trespassing. So what the courts have basically done is they've chipped away at the fee simple, right? They've chipped away at the fee simple. Because they said now whoever owns this land must allow the other party to be able to walk on it. But the flip side of that is that the licenses don't run with the land. So if the current owner sells it, I'm sorry, the person who made the renovation sells it, his successor doesn't get that benefit. So, as a matter of fairness, it's only for the benefit of the person who made the investments, not a third party. So that's a big difference between the easement and the license. It doesn't run with the land. So if you're trying to buy a piece of property from this party, you should know that you won't be able to trespass, and you'll be able to benefit. So it's almost like a life estate if you think about it, or at least not a life estate, but while the person owns it, this license exists. Once that ownership disappears, the license vanishes. Okay. So any questions in that case? Yes?
If it doesn't run with the land, then the interest ends on conveyance, what's stopping title owners from simply like conveying it to, an heir, and then relinquishing the interest?
Say that again, please?
So if it ends with the interest of the current owner,
Right.
the license, what's stopping title owners from simply conveying it to an heir, a son?
Why would they do that? That would be to their detriment. It would hurt them.
If they wanted to relinquish the licensee.
Why would anyone? But why would the person benefiting from it want to relinquish it?
I mean, I'm just trying to.
Well,
figure out if that's how
yeah,
it
I mean,
works.
but that's basically the thing. The property their heir inherits is not as good as what they have, right?
Okay.
The license does not run with the land. It's only because this person put the investment in. Now, the other flip side is because it's under a license, it's still permissive, and there's no claim for prescription. So you still don't start the adverse possession clock. So these prescriptions in this West Virginia case, I'm sorry, this Kentucky case, is a good illustration of how it's like a one-time deal, right? It's a one-time deal. The current owner gets some sort of benefit while he's in possession. If he loses possession, his successors don't get that benefit. So this is why it's always risky to put investments into property that you don't have a license for, or any sort of easement for. Because eventually the $25,000 you put into this will probably go to the trash. Make sense? Okay, so questions on that? All right, so what we covered today is this notion of easements, right? And so far it's actually pretty easy. I regret to inform you it gets more complicated. And specifically the topic for next class and the class after that is what does it mean for an easement to run with the land? And how do you structure an easement such that future parties are bound? And the answer is not simple. It's actually fairly complicated. But you need to be able to walk through each step of at any given point who owes what responsibilities. And this class is just the first early introduction to this for you to consider. Any questions on that? Oh yeah, Robert, please.
I have a question on the first case.
Oh,
Towards the end, they talk about the balancing of.
you're talking about the Christian Church Scientist case?
Yes.
Okay.
The balancing of the grantor's intent and the I guess the buyer, and they talk about how if they relied on the old rule,
Good.
they take that into account. Is
Yeah.
that still the rule, or do they still balance?
Yeah, I think they definitely consider the intent of the parties, right? Because Ms. McGugan made pretty direct that had she known the easement, what's that again?
Well, I mean the second part. Do they still take into account whether the person relied on the old rule? Because I mean.
Oh, you're screwed now. No,
Yeah.
at this point, I mean, this is I mentioned before, but in California, when a judge reverses a common law, that has a consequence, right? It means that anyone who gave legal advice on the old rule is out of luck, right? So imagine, right? Imagine you were a lawyer before this case was decided, and your client came to you and said, "Hey, is this deed valid?" Right? They reserved an easement for a third party. You're like, no, it's not valid. Go do whatever you want. Build a structure on this lot. Now you're screwed because the common law rules reversed. Anything else?
So even if those two cases were going around the same time,
It's
that one.
sometimes the courts will say this only applies prospectively, but I don't think this court made that distinction. They said we will not enforce the requirement that you have to do this two-step conveyance. Jean Paul?
Yeah, in the restatement third, it specifically remarks that the license would remain reasonably or until they can recover expenditures. Is that currently the modern view?
Well, I don't mention the restatement much because no one's actually adopted it. Unlike torts and contracts, people just haven't adopted the restatement of property. And property is a fairly state-by-state basis. But I'll give you this response. Once you move to the area of equity and licenses, there are no hard and fast rules. And if a court thinks that, okay, you can keep this easement until you recover your costs or this or that, they'll do that. I'm sorry, license. It's a very open-ended standard. Anything else? Anything else? Well, I will see you all on Tuesday. I apologize again for giving you the wrong room number. I'm gonna go move that sign right now for my other